All right, as we continue with trusts, we're going to be looking at the various types of trusts. But before we do that, let's make sure that we understand the requirements and the parties. So understand the relationship between the settlor and the trustee and the beneficiary. Once the settlor creates the trust, it is really between the trustee and beneficiary. And all that the settlor has potentially the ability to do is to revoke. Obviously, with the ability to revoke, the settlor maintains his or her ability to amend and alter. So if the settlor doesn't like the way something is going, they can certainly change the trustee, change the beneficiaries, and things of that nature. But as far as forcing the trust terms, it is really between the trustee and the beneficiary. Keeping in mind, if ever equitable and legal title end up in one back to the settlor solely in the hands of the settlor, then there is no trust. And why we would care about that is because upon the settlor's death, if there's no trust, it becomes a probate asset and thus controlled by the settlor's will or intestacy. Sure that you look at a relationship and analyze whether or not the trust requirements have been satisfied. You'll either be told there is a trust, or you'll be expected to analyze whether or not the relationship that is described to you in the facts satisfies the trust requirements. All right, so in terms of types of trusts, I want you to think about, first, there is something called a testamentary trust, which is embedded in the terms of the will, requiring both the will requirements of writing, signing, and witnessing, and the trust requirements be satisfied. It comes into existence upon the testator's death. At the end of the probate administration, there is a check written from the executor to the trustee, and that's where trust management begins. On the other hand, a settlor could create a trust during lifetime known as an inter vivos trust, keeping in mind the retitling of the asset from a probate to a non-probate, even if it's the settlor himself holding it as trustee, makes it a non-probate asset, passing outside the probate administration process. The idea of a revocable trust is that the settlor maintains the control. That is the default if the trust is silent as to the settlor's ability to revoke. Under common law, that was different. It was irrevocable. And it's no different for estate or federal estate taxes. It's included in the estate at date of value. The interests are created in beneficiaries at death because of the settlor's ability to revoke, alter, amend. Settlor has not parted with dominion and control. On the other hand, there's something referred to as an irrevocable trust, which means exactly the opposite. It is the settlor transferring property outside his or her estate without the ability independently to get those assets back, or change beneficiaries, or change trustees. You have to draft those documents in a way that accounts for all of those unknowns. Think about the spouse. Maybe you want to provide for a spouse only if the spouse and the settlor are married. If there's a divorce, provisions in the irrevocable trust need to be drafted accordingly. Again, take a look at the documents in the appendix and look how different the Form 5-1, which is your testamentary trust, looks different from your Form 5-2, which is the revocable trust, or Form 5-3, which is your irrevocable trust. With the testamentary trust, another name for this is a will substitute. It's very similar to a will, although it is a non-probate asset as opposed to a probate asset. Keeping in mind that the non-probate passes outside The statutory law in this area has provided various probate protections because it's so much like a will that revocation, the creditor period of time, and the elective share applies to revocable trust the same way it applies to a will. Make sure you take a look at the advantages and disadvantages of these various trusts so that you would be able to advise a client accordingly. The irrevocable trust, completely separate, used differently because you cannot get those changes back. Settlor himself or herself cannot change, need all beneficiaries and interest to consent, settlor's intent and purpose carried out. Again, take a look at the laundry list of advantages and disadvantages of the irrevocable trust in making sure you would understand when, hypothetically, you might advise a client to draft an irrevocable trust as opposed to an revocable trust. Charitable trust is unique in that there are some special rules that allow a court to substitute one beneficiary, one charitable beneficiary for the other. RAP does not apply, and it must be an indefinite beneficiary, not a specific person. Keeping in mind a charitable trust offers charitable deductions both during lifetime and upon death, and therefore the courts are going to do anything they possibly can to carry those terms out, even if it means replacing the beneficiary with one similarly with similar role as the one named. The Clymer v. Mayo case is a good case to see how sophisticated some of these trusts might be. It does a good job at looking at the pour-over concept. And I think, this is an interesting case because the divorce, well, now under the Maryland Trust Act, this wouldn't even be a case because there's automatic revocation in the event of divorce. That wasn't the case back at this time, although I think the court finds a way to get to that result. But most importantly, I want you to sort of try to understand the plan that was in place, this pour-over provision of the will, various trusts that were set up by the decedent in this case. So that, to me, is more important than the outcome of the case. It's just sort of like, from the facts of the case, understand the estate plan. Look at the arguments the parents made, the lack of property. That wasn't sophisticated enough, but they were able to make sure that the ex-spouse was not in the mix. They found a way to get there. They looked at it as all one estate plan, sort of made it as a will. And because keeping in mind the courts are not going to be able to reform something like this. But they looked at it as all part of one testamentary scheme. So they actually treated this inter vivos trust like a will. And that way they were able to get the now ex-spouse out of the estate plan. The ex-spouse's blood relatives were not. And I wonder why this might have been different from Friedman. Think about how this particular decedent didn't have any nieces and nephews or anyone else to leave the property to. So if you remember from Friedman, they found the revocation of the will extended beyond the spouse to those related to the spouse. Why didn't they do that in this particular case? Next case is the Baker case, and it looks at the living trusts prepared or how a lawyer's involvement with a non-lawyer was reprimanded. So take a look at the facts, understand what these lawyers and non-lawyers were doing. Essentially, the lawyer came into the mix just for purposes of drafting. The lawyer was also reprimanded for aiding in the unauthorized practice of law, and the court gives good advice to all lawyers. If you have doubt, don't do it. There's another ethics case. And then finally, we look at the charitable trust and the Cypre doctrine with Crawshaw, looking at the gist of a testamentary trust that was to provide loans for students at Marymount College, and how the court is able to ascertain whether or not the testator had general charitable intent, which essentially will be presumed unless otherwise indicated, and finding a substitute charity for 85% of the residual trust.